Once again, a good evening to everybody. I deem it a privilege to be in Madras. You see, we as advocates, we always valued the judgments which came from the Madras High Court. And I particularly learnt a lot of civil law from the benches which delivered the judgments in the Madras High Court. I therefore deem it a privilege to be in Chennai. We always say Madras, though it is now called Chennai. We all, I suppose, we are still old-timers. And I'm happy to be here today. And I think it's a privilege for me to be invited to deliver the Justice S Natarajan Centenary Commemoration Lecture and to make my humble contribution to the path of legal thought that Justice Natarajan's memory signifies. I must extend my gratitude to Sri Ramesh Rajan and his family and his brothers and their families for inviting me to deliver this lecture and for the kind words that have been spoken about me. Born on 29th October 1924, Justice Natarajan witnessed and contributed to the development of independent India's constitutional legal system. He was a contemporary of my father, who was born on 18 December 1924. So next month he would also complete his centenary. And they shared many benches together, including, I may say, as it is of recent and current discussion, 2 7-judge benches in India Cements Limited and Synthetics and Chemicals. Justice Natarajan was a part of that bench. My father presided as the Chief Justice, and Justice Sabyasachi Mukherjee wrote both those judgments. And the coincidence is that I, in a 8:1 dissenting judgment, I have upheld both those judgments in India Cements and Synthetics and Chemicals. Of course, mine is a minority view, but it is a happy coincidence to remember that today. Having received his early education in Salem, he joined Loyola College, Madras, and then the Madras Law College for his education in the law. Charting his journey as a member of the bar before the Madras High Court in August 1947, when we got our independence, Justice Natarajan's versatility and deep grasp of law was in civil, criminal, industrial, and labor matters. He was appointed as the public prosecutor in Salem in 1959, and thereafterwards he was appointed as the district and sessions judge in 1965. His judicial service was characterized by a pragmatic and intellectual understanding of the law. He was later elevated to the bench of the Madras High Court in 1973 and thereafter to the Supreme Court in 1986, and he retired in October 1989, a time which he admirably used in rendering judgments of significant import for the times to follow. He was also a part of the Thakkar Natarajan Commission, which inquired into a controversy. I think it is called the Fairfax controversy. His wife, Srimati Bhagirathi, was a source of great strength to Justice Natarajan. Even after retirement, the couple were very active socially, and as Mr. Ramesh Rajan said, they were very sought after, especially for being benign with their blessings to youngsters. The true measure of a judge's character and personality is through his or her judgments, providing for development of law. I deem it fit to mention a few judgments of Justice Natarajan that reflects his incisive commitment to the pursuit of development of law and its employ as a tool for social justice. He demonstrated his legal acumen and deep wisdom in his judgments and contributions to the salient 14 constitution benches he was a member of. In A.R. Antule versus R.S. Nayak, he was a part of the leading majority opinion authored by Justice Mukherjee, which, by a 5:2, set aside an earlier constitution bench judgment. Incidentally, the reference to the 7-judge bench was made by my father sitting with Justice Mukherjee on the correctness of the order of the Constitution bench. I may mention as of interest that Justice Venkatachalaya and Justice Ranganathan wrote the dissenting judgments there. His commitment to law as a tool for justice and respect for the Constitution shown in his judgment in Begum Subanu, wherein the country's dailies hailed it as a trend-setting judgment. Justice Natarajan held that the right of a Muslim husband to a polygamous marriage cannot act as a bar on operation of Section 125 of the CRPC. In a perfect confluence of judicial activism and restraint, Justice Natarajan was aware of the court's limitations through the centrality of the doctrine of separation of powers. This mindfulness of the delicate but functional balance that needs to be maintained between different organs of the government is most visible in his opinion in State of J&K versus Mahmood Ahmed. In that case, the High Court had said that Sections 8 and 14 of the Evacuee Administration of Property Act 1950 had outlived their purpose after 39 years of the Act coming into force, and directed officers of the state not to entertain any application made in future by persons laying claim to properties which had been notified as evacuee property. Justice Natarajan, espousing his respect for the constitutional separation of powers, effectively observed that the High Court was incorrect in nullifying a statutory provision by determining its utility, that being a matter of decision for the legislature. It is this judgment which has made me speak about the topic of today, namely principle of checks and balances under our Constitution. The fundamental principle of checks and balances under the Constitution rests on the fulcrum that the exercise of power by any one authority, namely the legislature, executive or judiciary, must be balanced and checked by the exercise of power by other authorities. Closely related to the principle of checks and balances is the functional principle of separation of powers. Its origin can be traced to the Locke's second treatise on civil government, or Montesquieu's The Spirit of the Law. The French philosopher Montesquieu emphasized the mutual exclusiveness of the three organs of the government, namely the legislature, the executive, and the judiciary. The purpose underlined in the separation doctrine is to diffuse governmental authorities so as to prevent absolutism and guard against tyrannical and arbitrary powers of the state. For it is Lord Acton who said that power corrupts and absolute power corrupts absolutely. This is also to protect the freedom of the people. In the famous case Keshavananda Bharati, the Supreme Court observed that separation of powers between the legislature, executive, and judiciary is part of the basic structure of the Constitution, which cannot be destroyed by any form of amendment. The concept of separation of powers creates a system of checks and balances, by reason of which the powers so distributed to each of the organs do not predominate or disable the other organs from exercising and discharging the powers and functions entrusted to them. In practice, the theory is accepted with the hope of coordination and cooperation between the three organs of the state to achieve the aim of upholding constitutional values, or if I may say, constitutional dharma, and the laws for the protection of people's individual and collective rights. Justice P. Satasivam, who is here with us today in Bhim Singh, said, "The Constitution does not prohibit overlap of functions, but in fact provides for some overlap as a parliamentary democracy. But what it prohibits is such exercise of power of the other branch, which results in wresting away of the regime of constitutional accountability." These instructive words encapsulate the pertinency and position of the doctrine of separation of powers in our Constitution, and therefore the reason for my choosing this topic, checks and balances under the Indian Constitution through a looking glass. The basic structure of our Constitution aids as a looking glass and takes us to a clearer picture of testing any exercise of powers. In that spirit, I would speak on the origins of the doctrine of separation of powers and its place under the Indian Constitution. And I would also speak upon parliamentary supervision of executive action. Next, I would speak on judicial review, which is a matter of checks and balances under the Constitution to check legislative and administrative excesses. And I would put forth the centrality of judicial independence to rule of law. Before discussing on the topic as such, let me ignite this audience with the recent judgment of the Supreme Court for a clearer concept of what I would like to say in furtherance of the topic. In re directions in the matter of demolition of structures, writ petition civil number 295/2022, it just came 3-4 days ago, it's not yet reported in the reports. The judgment written by Justice B.R. Gawai along with Justice Vishwanathan said, and I quote, "If a citizen's house is demolished merely because he is an accused, or even for that matter a convict, that too without following the due process as prescribed by law, in our considered view, it will be totally unconstitutional for more than one reason. Firstly, the executive cannot declare a person guilty, as this process is the fundamental aspect of judicial review. Only on the basis of accusations, if the executive demolishes the properties or property of such an accused person without following the due process of law, it would strike at the basic principles of rule of law and is not permissible under the Constitution. The executive cannot become a judge and decide that a person accused is guilty and therefore punish him even before the court could convict him by demolishing his residential or commercial properties. Such an act of the executive would be transgressing its limits." The Supreme Court went on to say, "The chilling sight of a bulldozer demolishing a building when authorities have failed to follow the basic principles of natural justice and have acted without adhering to the principles of due process reminds one of a lawless state of affairs where might was right. In our Constitution, which rests on the foundation of the rule of law, such high-handed and arbitrary actions have no place. Such excesses at the hands of the executive will have to be dealt with the heavy hand of the law. Our constitutional ethos and values would not permit any such abuse of power, and such misadventures cannot be tolerated by the court of law." Unquote. This is one stark example of executive excesses in recent years. Further, and in the era of tribalization or tribunalization, however you want to pronounce it, the constant refrain is that the executive trenches into areas of adjudication and therefore accused of usurping judicial functions by appointing persons with executive bias. The reason is, they say that the high courts have so much of docket load, so much of pendency. Therefore, let us create tribunals to unload the pressure on the High Court. Initially, it started with the Service Tribunal, Central Administrative Tribunal, State Administrative Tribunals, and that experiment has failed in certain states, and the matters, I am told, have gone back to the High Court. But then it went on from one tribunal to another tribunal to another tribunal. No doubt, in some cases, the tribunals may be a good opportunity for retired judges to have a rehabilitation. But at the same time, who are the members, technical or otherwise, who are assisting such judges is the question. In Roger Matthew, the Constitution Bench of the Supreme Court issued a writ of mandamus to the Ministry of Law and Justice, central government, to carry out a judicial impact assessment of all the tribunals. The central government responded with the notification of tribunal, appellate tribunal, and other authorities' qualification, experience, and other conditions of service of members' rules 2020. This was again challenged by the Madras Bar Association on the ground that the rules were violative of the principles of separation of powers and independence of judiciary. The Supreme Court has directed that the Union shall constitute a National Tribunals Commission, which shall act as an independent body to supervise appointments and functioning of tribunals, to consider disciplinary proceedings, and to take care of administrative and infrastructural needs of tribunals. This is in order to maintain independence in judicial adjudication. The call of the modern technocratic, transparent, and efficient governance structures beckons a constitutional regime of checks and balances that travels beyond traditional state actors. Rather, the structure of 21st century open governance frameworks makes it prudent to acknowledge that the regime of checks and balances also responds to citizen participation. Professor Jerome G. Kerwin, a professor of political science at the University of Chicago, in 1945 said, "The inextricable link between structure and governance in the following words," and I quote, "Forms of government, it is true, do not reform the men who administer them, but they do make it easier for good administrators to do the job well, and they do very often make it easier for the people to observe the operation of the government," unquote. Thus, an efficient rendition of principle of checks and balances allows and emboldens responsible legislators to effectuate their scheme for the nation, while still enabling harmonious coordination with other power holders and also ensuring open governance. In this regard, I must say that the relationship between the President vis-à-vis the Parliament under Article 74 and governors in relation to state legislature under Article 163 and the executive respectively have been the center of controversy in a series of cases before the Supreme Court. Although not entirely ceremonial in everyday exercise of executive power, the President and the governors have been given a certain degree of discretion also. Justice A. Ray, speaking for the Supreme Court in Samsher Singh, explained that whenever the Constitution requires the exercise of any power or function, the satisfaction of the President or the Governor is not their personal satisfaction or anybody else's satisfaction vicariously arrived at. I may say, it is the satisfaction in the constitutional sense, particularly when the aid and advice of the Council of Ministers is not contemplated. This is when there is purely discretionary exercise of power by the President and the governors of the states. Such is the friction between political incentives and constitutional methods that in a contrary landscape, checks and balances are necessary even on the lawmaking power of presidents and governors, acting on the aid and advice of the Council of Ministers. Equivalent to a parliamentary legislation, the Constitution authorizes the executive to exercise original legislative power. The President may promulgate ordinances under Article 123, and it is easy to remember the governors on 213, 123 and 213, that is how we studied as a student. Provided that at least one house of the Parliament or the legislature must not be in session, and that the President must be satisfied that circumstances exist which render it necessary for her to take immediate action. Practically promulgated by the President on satisfaction of the ministers, ordinances are products of legislative power vested in the executive and beyond the ordinary grounds of judicial review. Nevertheless, ordinances must be laid before both houses once the Parliament reconvenes. Finding a convenient path to lawmaking sans legislative approval, several governments have abused the possibility of re-promulgating ordinances. In the famous case of D.C. Wadhwa, the Supreme Court frowned on ordinances being kept alive for periods ranging from 3 to 14 years, merely by re-promulgation, and converted an exception into a norm. The Supreme Court denigrated it as Ordinance Raj. This usurpation of legislative power by the executive was held contrary to India's constitutional scheme. Ultimately, recently, a 7-judge bench in Krishna Kumar also affirmed the view that was taken in DC Wadhwa and held that repromulgation of ordinances is a fraud on the Constitution and a subversion of democratic legislative processes. On that note, I will now turn to judicial review of parliamentary and executive action. On September 17, 1787, George Washington, the then President of the Constitutional Convention, put in 2 sentences as the essence of the judicial task. He said, and I quote, "Individuals entering into society must give up a share of liberty to preserve the rest. It is at all times difficult to draw with precision the line between those rights which must be surrendered and those which may be reserved." Unquote. Drawing the line is, in my view, the core task of the judicial organ under the Constitution. Of all the unanticipated political developments since 1787, none has been more consequential than the acceptance of judicial review by the Supreme Court of United States in Marbury versus Madison. I need not go into the details of that case, but at that time, James Madison in 1788 on the separation of powers in Federalist Papers number 47, the quoting of that merits some interest. Quote, "The accumulation of all powers, legislative, executive, and judiciary in the hands or the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Unquote. Since then, this principle has been exported all over the world, including into India, where the Constitution, since its inception, in Articles 32 and 226, read with Article 13, have recognized the principle of judicial review. The principle has since been hallowed and cemented by reiteration by our constitutional courts. The critique that judicial review is illegitimately grafted into our popular government is wholly misplaced and in fact improper. For one, this idea suggests that democracy is meant only to reflect one popular opinion. That is not so. One single popular opinion is not the only opinion in a democracy. With all humility, I think it is reductive. The process of democracy, in my view, is meant also to refine and elevate public opinion from all angles and viewpoints. There cannot be only one public opinion applicable to all. Ultimately, democracy is also about arriving at a consensus by taking the best from a variety of ideas and opinions that emerge at a particular point of time. Therefore, in a true democracy, there cannot be scuttling of divergent opinion or thought, nor a curb on ideas which may appear contrarian. Secondly, and more importantly, democracy is dedicated to preconditions of liberty and equality. Without the judicial protection of individual rights against their encroachment, the preconditions of liberty and equality would fall. To be sure, my submission is not that majorities will necessarily fail those conditions, but the truth is that they often do. While majorities have a right to work their mistaken wills anyway, that right is not untrammeled. It is the judiciary and the judiciary alone that determines the limits of that right. In fact, the legitimacy of the courts comes precisely from the fact that courts act without reference to popular sentiment, and by doing so, they address injustices which majoritarian institutions are fundamentally incapable of addressing. In a succinct sentence in Marbury versus Madison, Chief Justice Marshall of the Supreme Court of the United States espoused the role of judicial review. He said, and I quote, "It is empathetically the province and duty of the judicial department to say what the law is," unquote. Under our transformative constitution, the power of judicial review has time and again been invoked to prevent and remedy injustice. Such an injustice could be a result of state neglect or action, or be a social malaise. To borrow the fallacious expression from Vivian Bose J., it has been a zealous endeavor of the Indian judiciary that the Constitution should work for the butcher, the baker, and the candlestick maker. The judges of the highest adjudicatory body in the world's largest democracy consider it their duty to redeem their constitutional oath and do justice no less to the pavement dweller than to the guest of the five-star hotel. These are the words of Justice Chinnapareddy in Randhir Singh. Therefore, it will not be excessive or out of place to say that the judiciary is at the epicenter of constitutional government. Our constitutional endeavor has been to ensure that judicial review acts as a measured but effective check on exercise of power by Parliament and the executive. Beyond the challenge to the vires of any act of Parliament or a state legislature as being violative of Part 3 of the Constitution, the judiciary is the bulwark against abuse of power by the executive, whether at the center or at the states and lower levels. Therefore, statutory provisions limiting the jurisdiction of courts and provisions seeking to exclude the jurisdiction of courts are strictly construed or struck down. One example of that is in Quixoto Holohon, where a challenge was raised to paragraph 6.1 of the 10th schedule of the Constitution, which seeks to impart finality to the decision of the Speaker or the chairperson as to whether a member of a house has become subject to disqualification because of defection. The Supreme Court held that such finality could not detract from or abrogate judicial review of the decision under Article 136, 226 and 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafites, non-compliance with rules of natural justice and perversity are concerned. More concerned with day-to-day governance, judicial control of delegated legislation deals with the concept of excessive delegation, substantive and procedural ultra-vires, and such other grounds of review. Additionally, judicial control is exercised over administrative discretion by way of judicial review when administrative duties are not undertaken in accordance with the recognized principles of administrative law. I need not go in detail about those to this enlightened audience, except referring to promissory estoppel, legitimate expectation, proportionality, restitution, and such other principles which are applied to strike down erroneous exercise of administrative discretion, which are of great importance in administrative law. Further, the checks exercised by the judiciary are not restricted to examining the compatibility of the content of laws with Part 3 rights, but also extends to judicial overview of actions within the legislative body and the manner in which such actions are conducted. Anil Kumar Jha is an example where the Supreme Court issued directions on the manner in which a trust vote in the Jharkhand Assembly should be conducted. To illustrate, judicial decisions have worked as checks and balances on prospective and sitting members of the legislature. In Association for Democratic Reforms, the Supreme Court held that the derivable from Article 19(1)(a) for voters is a right to know who they were electing. Therefore, the court directed disclosure to every voter of detailed information relating to a candidate. This carving of Article 19(1)(a) has contributed to new rights under Article 19(1)(a). In fact, the theoretical basis has been acknowledged since long. In State of Uttar Pradesh versus Rajnarayan, the respondent sought access to documents in an election petition, rejecting the state's claim of privilege from disclosure. The Supreme Court traced the right to know from the freedom of speech as it built on the ideal of transparency of governance. This approach, I find, acts as a dual check and balancing mechanism. The citizen parliament loop must be discussed in the context of Indira Nehru Gandhi versus Rajnarayan, wherein the Parliament used its amending powers to amplify a moral and legal wrong, and furthermore to validate an invalidating election by withdrawing the jurisdiction of the judiciary. The court finally held that such an amendment declaring the judgment void without removing the basis for judicial decision, making it without any judicial application to the facts of the case, would toll the death knell of the democratic structure of the Constitution. Justice H.R. Khanna opined that if the 39th Amendment was allowed to stand, the mechanism for determining the real representatives of the people in an election as contemplated by the Constitution would be destroyed, and a judgment inter se parties pending appeal would be declared void without any judicial application of mind. Thereby the separation of powers doctrine would be truly discarded. This brings me to the next theme, that is legislative overruling of judicial pronouncements. I would only touch upon it briefly for paucity of time, as I am conscious that there are other learned speakers to follow me. The legislative power to amend the enacted law with retrospective effect is not only subject to our legislative competence, but is also subject to several judicially recognized limitations, which I would not like to highlight for paucity of time. By ensuring that the legislature cannot simpliciter overrule judicial decisions, the principle of separation of powers is maintained. In NHPC, recently I had an opportunity to deal with the interlink between judicial review, separation of powers, and its inextricable relationship with rule of law. Such instances would amount to an attempt to legislatively overrule a court's judgment by a legislative fiat and would therefore be illegal and colorable exercise. The power of judicial review is a part of the basic feature of our Constitution, which is premised on the rule of law. Simply setting aside a decision at naught would not be sufficient. I would not like to go in detail with regard to Sita Soren and where the P.V. Narasimha Rao decision was overruled recently by the Supreme Court, which dealt with whether MPs and MLAs have constitutional immunity under Articles 194(2), that is for the state legislature, and Article 105(2), that is for the Parliament, involving allegations of bribery. This judgment marks a significant precedent, emphasizing that lawmakers are subject to anti-corruption laws and that legislative privilege cannot shield criminal or corrupt behavior. Recently, in state of Punjab, the Supreme Court said and explained that the governor is a symbolic and cannot withhold action on bills indefinitely. In an exposition of checks and balances between different constitutional post holders, the court explained that reconvening a sitting of the Legislative Assembly, which has not been prorogued, is an exclusive prerogative of the Speaker and not the Governor. This instance surfaces the presence and strength of checks and balances. There are more details about the said judgment, which I would not like to go about it. Then I would come to the question of judicial independence, a check to balance judicial powers. Necessary to the enforcement of checks and balances by judicial control is judicial independence. The inception point of any understanding of independence of the judicial organ is the doctrine of separation of powers and the consequent independence of the judiciary from the executive and the legislature. It is not only independence of the judiciary as an institution, but independence of the individual member of the judiciary. Where independence exists, courts are able to be more forceful mechanisms for defense of constitutionalism and justice. Article 50 of the Constitution urges for separation of judiciary from the executive in public services and the law. The focus of independence of judiciary is what Montesquieu conceptualized, that there should be institutional separation and judicial independence. Ultimately, it depends on every member of the judiciary. Political insularity is one aspect. The other is with regard to impartiality. The third component is the position of courts within the larger political system, and their functional relationship with the other branches of the system. Independence of judiciary is more closely related to supremacy of the law. Judicial independence and supremacy of the law work together to guarantee that rule of law is not to be eroded by political pressures in existence at any particular point of time. Insulating judges from political influence advances the same object. Both these concepts are therefore important underpinnings to the rule of law. The next aspect is whether independence of the judiciary is related to the concept of judicial accountability. My answer is yes. The two values are to be perceived as complementary rather than antithetical. Judicial independence is merely the other side of the coin from judicial accountability. The two are not at war with each other, but rather are complements. Neither is an end in itself, but rather means to an end, or a variety of ends surrounding the constitutional ideals. The further aspects on judicial independence I would not like to touch upon, except quoting Justice Frankfurter in Baker versus Carr when he said, quote, "The court's authority, possessed of neither the purse nor the sword, ultimately rests on sustained public confidence in its moral sanction." I am always concerned about the public confidence in courts. The rule of law, which is defended by an independent judiciary, plays a crucial function by ensuring that civil and political rights and civil liberties are safe and equality and dignity of citizens are not at risk. Ultimately, the extent of the judiciary and its independence relates to independence, impartiality, integrity of the men and women holding judicial office. It is therefore all important to appoint meritorious judges who have the pulse of the Indian society and the country in their hearts and the rule of law in their mind while seeking to render justice. It is the personality of judges that will determine, in truest sense, the extent of judicial independence and autonomy. Justice Natarajan, he personified what I just said. In my view, independent exercise of judicial power is not only a judge's prerogative, but also a duty. It is therefore important that judges decide on their own appreciation of the law and as per their conscience, unfettered by the views of others. It is ultimately the individual conviction of a judge, his or her courage and independence, which would decide matters before the law. From therein would be true justice. This is recently we find that the Supreme Court has once again come up with quite a few dissents, and I'm happy to say that both my learned sister Justice Bela Trivedi and I have dissented in the Constitution bench matters. Therefore, not that women are more independent as such, but I want to bring it as a happy coincidence from the aspect of independence of judiciary, because the expression of independence from another judge is also an aspect of independence. This is independence of judiciary in its most enlightened form, I would say. On that note, I conclude my lecture with a firm hope that all gathered here will reaffirm our commitment to securing independence of the judiciary, remain alive to the challenges to it, and be vigilant in safeguarding and strengthening the judiciary. With this lecture, I pay my humble tribute to Justice S Natarajan, and I thank the family of Justice Natarajan for inviting me to this lecture. As usual, my judgments are very long, and if I'm given a microphone also, I'm long. I'm sorry if I've tested your patience. I thank each one of you for your kind attention. Namaskar.
द वायर के और वीडियोस देखने के लिए सब्सक्राइब करें और बेल आइकन पर क्लिक करें। स्वतंत्र पत्रकारिता की आर्थिक मदद करने के लिए डिस्क्रिप्शन में दिए गए लिंक पर जाएं और अपनी राशि चुनें।